Yes.
Okay, Mr. Woodruff, you need to unmute yourself. Bill, can you send him a text? Alright. Yeah, according to this, he's all logged in. Miss Henry's not logged in either. Do you know where she is?
Maybe not. She called me yesterday. I was not able to, I tried to call her back. She was not there.
Okay.
So, I don't know.
Well, we plan on doing her next. Have you got a number for her? You can text her. Yeah, text her or call her if you would. Well, I don't show her in the way here.
I'm going to do what they'll do to give us a.
That's fine. Pause.
Video instead connecting with audio, and then it's good. I just spoke with Miss Henry. She's logging in now.
Okay. Mr. Woodruff is holding up his hand.
Any other question?
I don't know.
What do you think, sworn in or something?
Yeah, I'd love about that. Mr. Argino is still a city center. Oh, says Woodruff raised his hand. All right, Mr. Woodruff, I can see your hand. You need to unmute yourself. There's a button on your screen that you either, if you click on it, it's red with a slice through it, looks like a little microphone. You click on that, that will unmute you. If you're on the phone, it may say something like start audio or something like that. Send him a, see if he gets his message. Okay, we'll send him a message, chat message.
Recording stopped.
Okay. Usually it's when someone else is in this company. So, or dog, well, yeah, I don't see anybody here as cute as a puppy, so. So nothing from Miss Henry. Don't call out to the jail, tell them they won't get.
Okay. We'll do Bill's out there first. So Denny's not up here yet.
Yeah, we'll do Bill, she's got, one out there,
Right.
Brian Henderson.
Henderson, right.
It says it's connected, isn't it? According to the screen, he's connected, his mic is on mute. And we don't have video either. Okay, Mr. Woodruff, if you can hear me, call Mr. Armstrong.
This is Dan at Common Police Court.
You're on the phone.
Tell Sergeant Benson to go ahead and get him down to the viewing room with Henderson up first. Okay, and we're waiting right now. Thanks, bye.
Ms. Collins, Ms. Witt's here with her clients. So I don't know, are you going to be handling those in-person ones or Mr. Kane? I can pull it over the, we'll get those out of the way. I think she wants to be.
I'm not talking to you. I'm just talking about.
Hey, Bill, don't complain, what you do. Yeah, come on, man. I don't think there's anything else I can do for Mr. Okay, I said anything. Lower hand. Has to start video. Has to unmute. Okay, I lowered his hand. I didn't do anything except move to the bottom of my screen. Don't see anything from Miss Henry, so we'll go ahead and do a couple of these in for pre-trials. Kayla Valentine.
I'll have to run back and get that file in order. That was, I received a Zoom invite, so I thought we were giving Ms. Valentine the Zoom.
Yeah.
I'll be right back and have this file.
And then also, Janine Nicholas.
I have that with me.
One of those days, Judge.
Yeah.
Best laid plans.
Jail's not open.
Yeah, they were going to be ready at 20 after since I called them, and so I mean they had to round all 5 of them up.
Well, in the future, just let them know one because we run into another one of these issues like we are here.
Yeah.
Not waste time. I'm gonna try to call Mr. Woodruff again, Mr. Armstrong. Oh, he did? Okay, well, never mind. I guess we'll just have to order him to come in for okay. All right. And here comes jail. All right, well, we'll go ahead and do that. When we get done here, I'll just tell Marcia to set a status.
Valentine
All right.
on the record.
Yes. Okay. All right. ahead and do the first one, is Valentine, Caleb Robinson, yes, yeah, Caleb Valentine, all right. Case number 20 CR 126 and 20 CR 226, State of Ohio versus Caleb Valentine, President of the State, Assistant Prosecutor King, President of the Defense Attorney Daniel Witt, and are you, Caleb Valentine? Pardon me? Oh, no, I'm not talking to you. I'll be with you in a minute. I've got somebody else here. Sorry.
Keep your voice up.
All right, you, Caleb Valentine?
Yes.
All right. Ms. Valentine is charged in 20 CR 126 with, along with 2 additional co-defendants, as to with one count of possession of heroin, it looks like, and then in 20 CR 226 with failure to appear. Now, I believe this is a first pretrial on the 226 case, and I think maybe it's a first pretrial on both cases. All right. Is discovery complete, counsel?
Yes, Your Honor, the state it is.
It is, Your Honor.
All right. And do you anticipate any pretrial motions?
Actually, Your Honor, as I was looking through discovery, I realized that I did represent Gregory Ralph in county court for similar offenses. And I just disclosed that to Ms. Valentine as well.
Okay. Not these particular cases.
No, not these.
What was how long ago?
It was a 2018 case that was resolved in summer of 2019.
Okay. Well, at this point, I don't know if there's any issue or not. Doesn't seem to be. If you disclose that and have a problem with her representing you right now, I mean, it comes down to the point where, is Mr. Ralph been,
That case has been disposed of for a while.
oh, he's done?
He has. All the co-defendants cases are all resolved.
Okay, all right. So, he wouldn't be a witness in the case.
No, he was just present in the house where search warrant was executed. The discovery of heroin in this case.
All right. Well, at this point, I don't see a problem, but, you know, if you think that at any point you feel uncomfortable because of that, just let us know, and we'll, you know, I could appoint another attorney. At this point, I don't see that if he's not going to be a witness, that there would be anything that would have any bearing on the case at this point. Have you had to provide your discovery yet? This is just first pre-trial.
Yeah, it's just the first one.
All right, so good. Here's what we do by the final pre-trial, and any pre-trial motions also.
None that I'm aware
All right, and has there been a written plea offer provided?
of. There has.
Yeah, your client aware of it?
Yes, she is.
Okay. All right, yeah, I think we're set for second pre-trial, final pre-trial November 10, and trial dates on December 13th. All right, we'll see you back here then. All right, Ms. Dingus?
All right, Your Honor?
Yes. Okay, well, I'll do that. Well, actually, I've got to just ask him on you. Yeah, I've asked him on you. Okay, we'll do that. Okay. See what that does. All right, case number 21 CR 76, State of Ohio versus Geneva Dingus, President of the State's Assistant Prosecutor King, President of the Defendant, Attorney Daniel Witt, and you are Geneva Dingus.
Yes, Your Honor.
Dingus is charged with aggravated possession of methamphetamine and fifth-degree felony. This is, I believe, a final pre-trial. Trial set for the 15th of November. All right, discovery complete both sides.
It is, Your Honor.
Yes, Your Honor.
There's no pre-trial motions.
No, Your Honor.
Has there been a written plea offer?
There has.
We have a plea form on the bench, Your Honor.
Oh, I'm sorry, I didn't see it there. Okay. All right, Mr. Walters is still muted, huh? Can't figure out how to mute him. I've done everything I can. Have him, tell him to hang up or log out and try again, Mr. Arnold. Yeah, he's on the phone. Okay, before we do this, we'll go ahead and get Ms. Hatcher just asked one case of Ms. Henry. So Ms. Henry, Dean Henry will do it. If you would unmute yourself, please.
Yes, sir.
All right, thank you. Okay, this is case number 21 CR 145. Dave Ohio versus Leah Henry. This hearing is being conducted by Zoom. Ms. Henry is present. Her attorney is Catherine Hafner. She's present from her office by Zoom. And prosecuting attorney Collins is appearing on behalf of the state from her office. Defendant is charged along with Mr. Woodruff for burglary and theft. This is, I believe, this is final pre-trial, and I believe the trial date is probably November 15th.
Yes, it is.
Okay. All right. Now, is discovery complete on both sides?
As far as I know, it is.
Okay. And there've been no pre-trial motions, is that correct?
That's correct.
All right, and there's been a written plea offer provided?
I have received a written plea offer. When I went out to the jail, the police said to give discovery and the officers from the center, she had bonded out, I think it was that same day. So I just dropped there, I actually moved to Atlanta, but I've not been able to get with her to get her address to send it to her, so I do not think she's aware of all.
All right.
I am not, and we have been making contact the last 6 days.
All right.
That's correct.
All right, well, as soon as we're done with this, why don't you call her, Miss Henry, so you can make that, and then we'll need to get this set for a status conference then in the next week or two. But now, also, Miss Henry, I see that you didn't report to the probation department after you were released from jail. And, yes.
Yes,
Oh, she has, okay. All right, good, all right, good. All right. Okay, well, then get in touch with your attorney because we need to have another hearing date on this, okay? All right, thank you.
Thank you.
Yeah.
I told him what was set for a status hearing. He also said that the screen said that the host had disabled his video. He said to see us.
I have, I never did anything on that. I don't know what's going on. So, yeah, okay, this time we had to log off. Yeah, because I mean, I haven't touched anybody. The only thing I did was ask him to unmute and ask him to start video. And, I don't know, something crazy glitch going on. All right. Now I'm gonna go ahead and do Ms. Witt because she has to get back to her office to, do, pre-trials at 2 o'clock. So, this is, Geneva Dingus, case number 21 CR 76.
One moment. Jumping around here.
Need to go back on record on that, I'm sorry. All right, back on record on case number 221 CR 76, State versus Geneva Dingus. Then presented Ms. Dingus with a plea of guilty form, which indicates you're going to withdraw your not guilty plea, plead guilty to the charge of an indictment of aggravated possession of methamphetamine. Now, this is a 3-page document that's been prepared by the prosecutor's office from a form that they have on their computer, and they fill in the blanks that or the spaces that are applicable to you, and then they print it out. And on page 3, there are signature lines, and there's a sentence on the 3rd page that says, I enter this plea voluntarily. A little over halfway down, right below that signature, which appears to me to be Geneva Dingus. Did you just sign this document? Or did you sign it?
Yes.
All right, did you go over this with your attorney before you signed it?
Yes.
And did she explain it to you and answer any questions you had?
Yes.
And when you signed it, did you understand that this is agreement to plead guilty, which means there won't be a trial, the next step in your case will be a sentencing hearing?
Yes.
And was this something you and she had discussed before today? Okay, so when you came here today, did you think this was a possibility?
Yes.
Okay. And you've had enough time to fully consider this matter?
Yes.
You're not being rushed in any way into doing this?
No, Your Honor.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
All right, now the agreement states that you're going to plead guilty to the charge of aggravated possession of methamphetamine in violation of 2925.11 Ohio Vice Code, 5th County. And further states that you understand the possible maximum penalty for that would be 12 months in prison, 6 months is minimum if one's imposed. Fine is available of up to $2,500, and then there's also a possible license suspension from 6 months to 5 years. You understand that?
Yes, Your Honor.
You face any felony charges in any other jurisdiction?
Yes.
Where's that?
Cincinnati.
What are you being charged with down there?
Same thing.
All right. And have you, is that case still pending?
Yes, I got a court on the 26th.
Well, if you should be convicted in both counties, and if you should be sentenced to prison in both counties, those sentences could be ordered to be served consecutively, meaning one after the other. You understand that?
Yes, Your Honor.
Right now, are you currently on probation, community control, parole, or post-release control for a felony anywhere?
Just a minute.
Under the law, if you are convicted of this offense, and if you should be sentenced to prison, once you complete the prison term imposed by the court, it is possible that the adult parole authority, at their option, would put you under what's called post-release control supervision for up to 2 years. That means you can be supervised by a parole officer the terms they set, because the court's not involved with that, and if during that period of time that you're being supervised, they determine that you had failed to comply, they can return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. However, if you are convicted of felony law and post-release control supervision, then in addition to whatever sentence the judge in the new case could impose, that judge could also impose an additional sentence in this case for committing, or I should say, for committing an offense while under supervision in this case, to a term of 1 year or whatever time is left on the 2 years of post-release control, whichever is greater. If that occurred, that would be served consecutively with sentence in the new case. You understand that?
Yes, Your Honor.
Now, the law might require to sentence you to prison. I can't impose what's called community control or non-prison sanctions. That means instead of going to prison, you put under supervision of a probation officer under terms set by the court for a period of up to 5 years, and if during that period of time probation tells you were not in compliance, they would file a written notice at the court, provide a copy with to you, and you would be suspended in a hearing, and in a hearing you would be entitled to be represented by counsel. If the outcome of that hearing was that you failed to comply, then at that time the court would revoke your community control and then sentence you to prison for 12 months, fine you $2,500. You understand that?
Yes, Your Honor.
The charge alleges in the indictment that on or about October 23, 2020 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 Narcotics Code. So that's the charge, aggravated possession of methamphetamine, and those penalties I just described. Now, you understand the nature of that charge, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
Have you discussed the charge, the evidence in the case, possible legal issues in the case, possible offenses you might try to raise in trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty?
No.
Now, the agreement states on page 2, there's 2 sentences printed in bold and underlined, and read, defense line, plead guilty to the indictment, state defense jointly recommend community control, substance abuse treatment. Anyone promise you anything other than that to get you to plead guilty?
No, Your Honor.
Under the law, the matter of sentence is reserved to the judge, not the parties, and so even though there's an agreement you should get probation in this case, once I've heard all the information submitted to me, I don't have to follow that recommendation. I could decide that instead your prison term should be imposed, and or a fine, and or a license suspension. You understand that?
Yes, Your Honor.
Do you hold any license or certificate from any state agency or any trade or profession?
No, Your Honor.
You have certain rights you need to understand before you can accept the plea. First of all, you have a right to have counsel. Ms. Witt's been appointed to represent you, not simply to work the case out, but to provide any defense that's available to you under the law that you wish her to provide. So if you decide you don't want to do this, you'll still be represented by an attorney. She'll defend you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county, summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented, the jury will be instructed on the law. Then those 12 jurors would have to decide by unanimous verdict, meaning they would all have to agree whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial. And in that case, you would have to hold a court bench trial, meaning instead of the jury hearing the evidence, it would be the judge would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront witnesses against you and cross-examine through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence and help your side of the case. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. If you have witnesses you're not certain going to come in voluntarily, you request court issue a court order, that's a subpoena, and that forces those people to come to court to testify for you, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
Under the Constitution, you have privilege against self-incrimination, which means you're not be forced to give evidence in a matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, it's your decision, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, with one exception, and that is if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden is on the state to prove that you are. So, you don't have to present any evidence at all. I front you can, but you're not required to, but whether you do or not, the burden will be on the state of Ohio to prove your guilt, prove beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
And you pled not guilty originally, that plea denied the allegations, and the indictment denied you committed any crime and exercised or invoked all the rights I just described. Change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations, admits that they're true and constitute crime, and that you're the one who committed that crime. And that plea gives up all the rights that I've just explained to you today, except the right to have an attorney. Always have the right to have an attorney no matter what you plead, with that exception. Plead guilty, wage gives up the right to have a jury or court trial, wage gives up the right to confront witnesses against you to cross-examine for your attorney, wage gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. Wage gives up your presumption or your privilege of self-incrimination, because that's what's used to find you guilty if you plead guilty. And finally, a wage gives up your presumption of innocence, because if you say guilty, the state doesn't have to prove guilty. It also subjects you to being sentenced immediately by the court, and it also wage gives up any right to file an appeal that you think you may have had up to this point in the case. Now, you should be sentenced to the maximum sentence, or under certain circumstances, you can file an appeal. That would have to be filed for 30 days for sentencing if you're being filed. You understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
Do you have any questions about the plea or the possible penalties?
No, sir.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
Yes, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak to your attorney about before we go any further?
No, sir.
And is it your decision to withdraw your not guilty plea and enter a plea of guilty to the charge as we've just discussed in this plea agreement?
Yes, sir.
Okay, then as to the charge which alleges that on or about October 23, 2021, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance of methamphetamine, violation of Section 2925.11 of the Ohio Vice Code, charge of aggravated possession of methamphetamine, a 5th degree felony, carrying possible prison term between 6 to 12 months, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Thanks, be seated. All right, the court finds that under the state open court, defendant provides all constitutional rights made knowing, intelligent, and voluntary waiver of the same pursuant to criminal rule 11. Please accept the court file. Defendant's found guilty of the charge as set forth in the indictment. The court will order a pre-sentence report be prepared, and that the probation department includes an assessment for substance use disorder and or mental health treatment. Sentencing will be set for November the 18th at 1 p.m. Fulton, you want her to just come on down right now? You had an appointment?
Yes, Your Honor, she came over.
Okay, all right. Okay, so as soon as you're done here, the right now information, ask for Mr. Fulton.
Yes, sir.
Anything further, counsel?
No.
You also have to get an assignment notice from the bailiff here, and then you won't have to be here on your court date, which I think is maybe November 15th. All right, thank you. All right, now we'll go to the jail, Mr. Henderson. Okay. Case number 21, CR 169, State of Ohio versus Ryan Matthew Henderson. Henderson's appearing by video from the Justice Center, by Zoom, I should say. His attorney, Wayne Armentrout, is also appearing by Zoom, as is the prosecutor, Mr. Collins, representing the state. This is a pre-trial defendant's charged with aggravated trafficking of methamphetamine, aggravated possession of methamphetamine, and there's a court specification. This is the first pre-trial. Final pre-trial set for November 3rd, and we have 11/15 trial date. I see the state provided a bill of particulars and discovery. Have you provided yours yet, Mr. Armentrout? Alright, that'll be due by the final pre-trial. Do you anticipate any pre-trial motions? Yes. Alright, well, that'll be due by final pre-trial as well. And then you just have been written out provided. Okay. Alright, anything else that we need to discuss? Alright, your attorney will be in touch with you then, Mr. Henderson, and we'll see you the next time. Thank you. Okay, let's go to the Jacob Wright. Officer will lead Jacob Wright next. All right, are you Jacob Wright?
Yes, sir.
All right, this is case number 21 CR 128, State of Ohio versus Jacob Wright. This hearing is being conducted by Zoom. Mr. Wright's appearing from jail. His attorney is Dennis Kirk. He's appearing from his office. The prosecuting attorney and Collins is appearing from her office. Defendant is charged with aggravated possession of drugs, third-degree felony. Said this is the first pre-trial, final pre-trial set for the third trial date November 15th. See, the state provided discovery and a bill of particulars. Have you provided yours yet, your discovery yet, Mr. All right, that'll be due by the final pre-trial. You anticipate any pre-trial motions? Okay. Has there been a written plea offer provided? All right. Have you got that, Mr. Kirk?
I do have that. I will be out to see him with having been ill, like during work today, so I don't maybe go out and see him.
Okay. All right. Anything further to come before the court on this case? All right, then your attorney will be in touch with you, Mr. Wright.
All right.
Thank you. All right. Derek Osborne is next. This is case number 21 CR 138, State of Ohio versus Derek J. Osborne. You're Derek J. Osborne.
Yes, sir.
Mr. Osborne is appearing by video from the Justice Center. This is a final pre-trial. We have a trial date of November 15th. His attorney, Dennis Kirk, is appearing by Zoom from his office, and the prosecutor responds from hers. I see the state provided the discovery and bill of particulars. Have you provided your discovery yet, Mr. Kirk?
I had not. I was intending to until I got ill, so I will provide that.
All right. Do you anticipate any pre-trial motions?
Not at this time.
All right. Has a written plea offer been provided?
Yes, Your Honor, on September the 2nd.
All right. You're a client aware of that yet, Mr. Kirk?
He is aware.
Okay. All right.
I did go to reach a resolution to start with having been out.
Sure.
But not see.
All right. Well, let us know, and we'll set a status conference or a plea hearing. That's what comes up. Anything further? All right. Your attorney will be in touch with you, sir. Thank you. All right. Thomas Malone. All right, case number 21 CR 158. State of Ohio versus Thomas Sean Malone. Are you Thomas Sean Malone? And Mr. Malone is appeared by Zoom from the Justice Center. His attorney is Dennis Kirk, is also present by Zoom. His office, Prosecutor Collins, is present by Zoom. Hers, defendant is charged with malicious assault and a peace officer failure to comply with the order or signal of a peace officer. I believe this is a first pretrial. Final pretrial set for the 3rd of November, and trial is set on the 15th. I see the state did provide discovery last week, and Bill particular, you received those, Mr. Kirk?
Yes, they did.
All right. Your discovery will be due by the final pretrial, and do you anticipate any pretrial motions at this point?
Not at this point.
All right, has there been a written plea offer provided?
Yes, Your Honor.
All right, has your client aware of that yet, Mr.
Not
Okay. All right. Anything further we need to discuss then?
yet. We'll be out to the jail to see what's
Okay. All right. We'll see you here then for the final pretrial. Thank you, Mr. Malone. All right, Jonathan Peterson. Deputy, I see that Miss Purcell's not scheduled at 2 o'clock till 2, but her attorney is logged in, so if you could get her and have her ready after this one, we'll get her done a little early.
Yes, sir, I'll be there as soon as we're.
All right, thank you. Okay, case number 21 CR 174, State of Ohio versus Jonathan Douglas Peterson. You're Jonathan Douglas Peterson. All right, Mr. Peterson's appearing by Zoom from the jail, appearing on his behalf from his office is Mr. Kirk, and also from the prosecutor's office, Mrs. Collins, prosecutor. Then is charged with 2 counts of rape, both first-degree felonies. This is a first pretrial. We have a trial set for the 3rd, or the final pretrial on the 3rd of November, and a trial set on the 15th of November. The state's discovery did get filed late last week, and Mr. Kirk, did you get that? Your discovery will be due by the final pretrial. Are you anticipating any pretrial motions?
With the possibility of competency, I know we did some stuff that we just were going to develop done through the forensic center. So I believe I'll be filing something related to competency.
All right. Has been a written plea offer provided yet?
Yes, Your Honor.
And you have that, Mr. Kirk?
I did receive that, yes.
Okay. Is your client aware yet?
Not yet.
Okay. All right. Anything else to discuss on this case?
Your Honor.
All right. Mr. Peterson, your attorney will be in touch with you then. Thank you. Ms. Wood, if you could text your client, Mr. Manring, about his hearing, we can go ahead and get him done early as well. He's not set for another half hour.
Yeah, we don't have, what status of Woodruff?
Pardon me?
Woodruff.
Woodruff is going to be reset.
Okay. So Purcell will be next.
All right, are you Carissa Frankie Dell Purcell?
Yes, Your Honor.
It's case number 21CR176, State of Ohio versus Carissa Frankie Dell Purcell. Purcell is appearing by by Zoom from the jail. Hearing being conducted by Zoom due to COVID-19. Defendant's attorney Daniel Witt is present from her office, and the prosecutor is present from her office. Defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. This is the first pretrial. Final pretrial set for November 10, and trial date is set for December the 13th. Now, I see that the state filed its bill of particulars and discovery last week. You received that, Ms. Witt?
Yes, Your Honor.
Right. Well, your discovery will be due by final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
Has there been a written plea offer provided?
Yes, Your Honor.
Is your client aware of it?
Not yet, I will let you know for receiver soon.
Okay. All right, are there any other matters that we discuss at this point?
No, Your Honor.
All right, the attorney will be out to talk with you about the matter, then, Ms. Purcell. We'll see you next pretrial. Thank you. Ms. Witt, if you can get a hold of Mr. Mandarin, we can do his as soon as he's logged on.
I just called in to get the phone number.
Okay?
We've got bond review on one at the jail, but Sarah's not here.
Yeah, it's not till 2:30.
Yeah.
I think we're just using this session for the Zoom. So we'll just have to stay logged on.
Yeah, there's, I don't know if she's getting ready to log you out or what she's doing there.
Yeah, we're done until 2:30. So you can either mute, stay on, or sign off and sign back in at 2:30, whatever you want to do. We'll be using the same session that you were on now. Case number 21 CR 126, State of Ohio versus Thomas R. Mandarin. This hearing is being conducted by Zoom. Mr. Mandarin has not been able to log on. He's in the Bliss area. His attorney, being conducted by Zoom. His attorney is present from her office, Daniel Witt, and present from the prosecutor's office, prosecuting attorney, Mrs. Collins. My understanding, Ms. Witt, from our discussions on record, is that Mr. Mandarin's diagnosed with COVID.
Yes, sir.
All right, and my understanding there was, there appears to be an agreement in this case.
There is. Your Honor,
Yeah.
I did check with Catherine while we were off record. He didn't call and schedule an emergency appointment today. He called and asked me to pick his gun back up.
If he could pick his gun back up.
Yes.
Okay. Well, then, I'm sure.
He didn't say anything about the emergency. She didn't know that's why he was calling.
Okay.
She told him to call her and his attorney.
All right. Well, Ms. Witt, you're requesting a continuance then of the trial date to give you some more time, off your client and get his appointment arranged.
Yes, sir. I did advise him to contact and schedule his interview for the emergency.
Yeah, well, he hasn't been calling in regularly either. She might tell him to do that. He called in once. So I did give him leave to report my phone since he's so far away. So telling he needs to take advantage of that and do it. All right, so the trial set for November 8th will be continued. And we'll set it for a pre-trial on, let's see, November 18th at 2 p.m. And that'll be, we'll have to make that in person unless he can be guaranteed to get to a good location for reception. And then the trial date will be set for December 16th at 8 a.m.
And then you might let him know that he needs to call and ask for an emergency appointment, not say he's going to get it done. She didn't know he was trying it out.
Yeah. Okay. Anything else? All right, well, let's handle all these cases then, and Ms. Collins, as I said, will be doing the bond review on the same invitation, so I'm just gonna leave this open. And mute myself, and do the same until 30. Okay, off record.
Off record.
Is this Sherber?
We have the bond review on Camp Crampton, and then this is Mr. Sharonberg here.
All right,
Would do.
all right, are you, Joseph Crampton there in jail? Mr. Crampton? Well, I'm leaving.
Your Honor, do you want me to go to the law library? Okay.
Just call us, it should go into this one.
All right, this is, case number 21 CR 78 statewide versus Joseph Crampton. You're Joseph Crampton?
Yes, Your Honor.
All right, Mr. Crampton is appeared by Zoom. Your attorney is here, in court, but she's also got another case here, so she's, here in court with Ms. Barber. And the prosecutor is also present, assistant prosecutor. This is a bond review hearing. Mr. Crampton was arraigned and the bond was set in the absence of counsel on, Monday. And, pursuant to Rule 46, since bond was set in the absence of counsel, court required to conduct a review. Bond was set originally amount of $2,500. Ms. Barbara, anything you'd like to say regarding the bond?
Your Honor, having just received this appointment, actually, I got the board yesterday. I have not had time to go out to the jail to speak with my client. Would request that since he is unemployed, that the bond be set at an OR, a $0 bond with an OR option, since he's unemployed, he clearly can't afford to work extra.
All right, Mr. King, anything you want to say?
Your Honor, I think it's called log into the Zoom on this one. She has to file online.
Oh, okay. Sorry about that. Well, there it is. All right, Ms. Collins, Ms. Barber is present in the courtroom, because she has another hearing in person here. She's already spoken on the matter of bond and realized you were handling it, so you have anything, she'd asked the court to reduce it to an OR.
I would ask the court to leave the bond in place. Would note that, this is a case that was indicted back in May of 2021, and we find the defendant and warrant has been issued for his arrest because, as a confinement.
All right. I think Mr. Crampton, I think you told me you had you served current agreement previously, haven't you?
Yeah, I didn't know about that. I did not.
Yeah. Well, how many times have you been to prison?
I've been here 20 years.
All right, so how long have you been at the residence there at 36? Yeah,
I've been there for the last 3 years.
and you've been working?
Yeah, I work at.
Where at?
I work for a public tax. I'm not working at Franklin. I'm laid off.
Who else lives there at that address with you?
My mom and dad.
Okay. All right, I'll reduce the bond to $1,000, plus the OR and $171 deposit. If you do make that bond, you report to probation and you're under the same other conditions that you're making. All right, thank you.
I'm right now.
Okay, well, that doesn't make much difference, that doesn't. Okay, all right, thank you. right, let's go on record on Scharenberg now. All right, case number 21 CR 130, State of Ohio versus John William Scharenberg, present for the state, is Assistant Prosecutor King. Present for the defendant is Sarah Carter, Attorney Hillsborough. You are John William Scharenberg.
Correct.
All right, Mr. Scharenberg is charged with possession of cocaine and fourth-degree felony. The matter was referred for a pre-sentence report, pre-hearing report on the defendant's motion for intervention in lieu of conviction. I did receive a letter from Another Chance in Greenville indicating that, which is former Friel Associates, indicating that he has a graduated alcohol PD group and relapse prevention and is now attending bi-weekly sessions. And will continue until probation leave. And I did receive a report from Mr. Bolton, and in case the defendant is eligible, he's criteria. Quite a few traffic violations, classified traffic violations or low-level misdemeanors, but no prior convictions. All right. So, Mr. Scharenberg, I've been presented with a plea of guilty form with law of entry that would grant intervention in lieu of conviction and stay proceedings for treatment. And this agreement is, I believe, 4 pages long. The agreement is 2.5 pages, and then there's a page and a half of entry. You know, on page 3, there are signature lines, and there's a sentence that says, "I enter this plea voluntarily." Immediately below that, there appears to be signature defendant John Scharenberg. Is your signature on that?
Yes, sir.
When did you sign this document?
When it knocks at courthouse, I met Sarah.
Okay. And when you signed it, did you understand that this is agreement to plead guilty, which means there won't be a trial?
Yes.
Now, I'm required to explain it to you, I'm sure your attorney has, explain to you what this procedure is. Normally, if someone has a trial, is found guilty, or if they plead guilty, then the court has to impose a sentence, and that could be jail time, or in this case, prison time of between 6 and 18 months. Could be a fine of up to $5,000. Could be a license suspension of between 6 months and 5 years. Or it could be community control or probation for 5 years, or a combination of those things. Now, there is a procedure in the law that provides that if substance abuse was a primary factor involved in the offense, and a person is involved in a certified treatment program, which you are, then if a person pleads guilty, instead of being found guilty, the court can refer them into the intervention program and stay the case. What that means is if the case is stayed, it means it's just a stop, put on inactive status, and then the court waits for the report of the probation department about and the providers about your treatment and your supervision. So what happens is, I don't find you guilty, even though you plead guilty, even though there's a record in the file that says you pled guilty. You're not guilty because, number one, I haven't found you guilty, and number two, until you're sentenced, you're not considered to be convicted. And so if somebody asks you, you can say, I'm not convicted because I'm into the version or into the intervention program.
Right.
Now, that can be from 5 years. I usually make it 2 years. One of the statutory requirements is you have to remain alcohol and drug free, other than those for which you have an lawful restriction, and for at least 1 year. And you have to comply with certain conditions along with the treatment plan that you're in. Now, if you successfully complete that and pay your court costs and any programming fees, and comply with the terms of supervision, which are much less stringent than if you were convicted, then the court, once it receives a notice from the probation department, dismisses the case. So even though you pled guilty, the case is dismissed. And then you can have that record sealed, and that's usually, I usually go ahead and set those automatically for a hearing and seal the records unless something happens between that time, during that time period is pending. And so far, I have not had anything that haven't sealed. And then that means that the record is removed from the public records and from all law enforcement records, and no one has any access to do that unless you should see that, unless in the future you should get arrested again or charged again, in which case the court, probation officer, probation or prosecutor's office can look at those records. So the advantage to you, Mr. Sherberg, is that you plead guilty, but you're not found guilty, and if you plead your treatment and stay in compliance with the rules of supervision, then the charge is dismissed and you've never had a felony record. The disadvantage to you is that this is your last chance to stand on a plea of not guilty and defend against the charge. So you don't get to go through intervention and then come back and say, well, it didn't work out, then let's go ahead and have a trial. You can't do that. So that's the disadvantage. Yep. Yeah. You have any questions about that?
Yes, sir.
Okay. All right. Well, the agreement then says you're going to plead guilty to the charge possession of cocaine under 292511, the Ivory Code of 4th-degree felony. Further states that you understand the maximum penalty for that if convicted could be 18 months, minimum would be 6 months in prison. There could be a fine of up to $5,000. There could also be a license suspension of 6 months to 5 years. And you're not facing any felony charges anywhere else, right?
Sure.
And you're not on probation, free control, parole, or post-release control for a felony.
No.
All right? Now, since this is the last chance to stand on not guilty, they have to give the plea, you have to give the worst case scenario. So, if you fail to comply with the conditions of supervision, then the probation department will file a written notice of that with the court and serve you a copy. There will be a hearing set, and you would have an attorney present. If the outcome of that hearing was that you failed to comply, then at that time the court would find you guilty, and then you would be sentenced. Now, if that happens, the sentence, as I said, could be prison, could be community control. Community control means that you be supervised under more strict conditions, a lot more conditions, and that could be for a period of up to 5 years. And the same thing works as it does in the intervention program. Is if they felt you're not compliant, file a written notice out of the court, serve you a copy, you'd be entitled to have a hearing, have an attorney, and if the outcome of the hearing was that you had failed to comply, then at that time the court would go to community control and then sent you a period of 18 months to fine you $5,000. You understand that?
Yes, sir.
Now, if that should happen, and you went to prison at some point for this charge, once you complete the prison term, the law provides that the adult parole authority, at their option, can choose to put you under post-release control. This is an older form, it's 2 years now, change that. It says 3 in this form, now it's 2 years, it's maximum under the law, changed September 30th. So that means you would be supervised by a parole officer on the terms that they set for up to 2 years. If during that period of time the parole authority found that you failed to comply, then they have the authority to return you to prison as a sanction for that violation, to serve an additional period of up to 9 months for one or more violations, although half of your prison term is the max or the cap. So if you receive a term of less than 18 months, then whatever half that would be the maximum. But if you commit a new felony while you're under post-release control, then in addition to whatever sentence can be imposed in the new case, that judge is also authorized to sentence you for committing that violation while under post-release control, in this case, to an additional period of 1 year, whatever time left on the 2 years post-release control, whichever is greater. If that occurs, that has to be served successfully sentence in that new felony conviction. You understand that?
Yes, sir.
All right. Now, the charge alleges that on or about February 17, 2021, in this county, he did knowingly obtain, possess, or use a Schedule II controlled substance with cocaine, an amount equal to or exceeding 5 grams or less than 10 grams of violation of section 29, 25, and 11 of the Ohio Revised Code. So that's the charge. You understand the charge and possible penalties?
Yes.
Okay. Now, you discussed that charge, the evidence in the case, possible legal issues of the case, possible defense you try to raise a trial, and possible outcomes of the trial with your attorney.
Yes, I have.
Are you satisfied with your advice and confidence in this matter?
Yes, sir, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, I'm not.
Are you taking any prescription drugs?
Yes, I am.
Do they affect your ability to understand what's going on or relate things accurately?
No, it's just for pain. I just got out of the hospital for
I
me.
saw that you had knee surgery.
Yeah.
All right, have any, other than being promised to be put into the intervention program, has anyone made any promises to you to get you to plead guilty?
No,
Has
sir.
anyone pressured you to make you plead guilty?
No, sir.
Right? Now, do you have any license or certificate from any state governmental agency that regulates any profession or occupation?
No, sir.
Right? Now, you have certain constitutional rights you must understand, because again, this is your last chance to stand on an ongoing plea. So, first of all, you have the right to counsel. Ms. Barber is appointed to represent you, not simply to work the case out, but to provide any defense might be available to you under the law that you wish to provide. So, you decide you don't want to plead guilty, but the defendant against this case, she's still going to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
In the Constitution, you have a right to a jury trial, in which 12 people will be selected, a group of citizens who live in this county that are summoned for jury duty after trial day. Once they are selected, the evidence will be presented, the judge will instruct them on the law, and they will decide whether or not the state proves your guilt on the charge. And that decision would have to be unanimous, meaning all 12 of the jurors would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and then in that case, you would have what's called a court trial. That means that the judge would be the one to hear the evidence instead of the jury. The judge would apply the law. The judge would decide whether or not the state proved your guilt, proved beyond reasonable doubt. You understand that?
Yes, sir.
Right, under the Constitution, Mr. Schoenberg, you have a right to confront witnesses against you, cross-examine for your attorney. So what that means is the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called a cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a court order that's called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to. Even though they don't want to be here, this is the same way the state witnesses are required to come to court. You understand that? Sorry.
Yes.
Now, under the Constitution, you have the privilege of self-determination. What that means is that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify, and I'm using this in any way, but any person, no one can comment about it, except for one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof is on you to try to prove you're not guilty. The burden of proof is upon the state to prove you're guilty. In fact, at trial, you don't even have to present any evidence at all in your own defense. You may, but you're not required to, whether you do or not. The burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged or proof beyond reasonable doubt, which is the highest burden of proof that's found under the law. You understand that?
Sir.
Right, now originally entered a plea not guilty, Mr. Schoenberg. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that there are crimes, that you committed that crime. And that plea gives up all of the rights that I've just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty will give up the right to have a jury or court trial, give up the right to confront witnesses and cross-examine through your attorney, The waiver give up the right to use the power of the court, power of courts to speak court to testify for you. Same as the state. The waiver give up your privilege of self-determination because you're saying you're guilty, that's what she finds you're guilty. And it waiver gives up your right to require the state to prove your guilt, because if you say you're guilty, the state doesn't have to prove your guilt. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if you are sentenced to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed in 30 days of your sentencing entry being filed. You understand all that?
Yes.
And are you a U.S. citizen?
Yes.
And are you entering into this agreement to plead guilty voluntarily?
Yes.
Right now, Mr. Schoenberg, do you have any questions about the intervention program, what's required for you to be successful?
No, sir. Me and Mr. Fulton and Dave, my foster, my probation officer, we done discussed it. I filled out my paper. I went to second chance yesterday after I got out of the hospital and stuff. And seen Samantha. I think I got everything. Okay, I got 9 months under my belt, clean and sober.
All right.
Keep on going.
Okay. Have any questions about the charge and possible penalties?
No, sir.
You understand it?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yeah, I understand.
Any questions about what pleading guilty means or what the consequences that'll be if you enter right here today?
Yes.
You have any questions for me?
Oh, no, I know.
Okay. Now, do you understand?
Yes.
Okay. Is there anything you'd like to speak with Ms. Barber about before we go any further?
No.
Okay. Have any questions about anything I've explained?
No.
Right, then is it your decision to withdraw your not guilty plea, plead guilty to the charge in the indictment pursuant to the terms of this agreement we've just gone over? Yes? Okay. Please speak up.
Okay. Yes.
Okay. Yeah, stand up if you would.
Stand up.
Oh, I'm sorry.
That's okay.
All right, now, as to the charge that alleges that on or about February 17, 2021 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with cocaine, amount equal to or exceeding 5 grams or less than 10 grams, in violation of Section 2925.11 Revised Code, Revised Code, charged with possession of cocaine, a fourth-degree felony, carrying a possible prison term of 26 to 18 months, fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? How do you plead?
Not guilty.
I forgot he's part of it.
It's okay.
Oh, yeah.
Guilty.
Oh, guilty. Guilty.
Okay, thank you. All right, you may be seated, Ms. Schoenberg.
Okay.
All right, now, the court finds that the defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same extent from 11, and has entered a plea of guilty voluntarily. The court finds that the defendant's drug dependence was a factor that led to the criminal activity with which he's been charged, and rehabilitation through treatment will substantially reduce the likelihood of committing additional future criminal activity. He has been accepted in the appropriate certified treatment program at another chance. He is otherwise eligible for free control. He's not a dangerous offender or repeat offender, and he's otherwise eligible for intervention for such criteria set forth in the statute. The court therefore orders that the defendant's guilty plea be accepted, but there'll be no finding. Guilt at this time. Instead, the case will be stayed pending a report from the probation department as to the defendant's progress in the program. He shall be placed on community control supervision under the supervision of the probation department for a period of 2 years under the terms that have been established for that program. He will successfully complete the intervention plan, including the requirement that he abstain from using drugs or alcohol for a period of at least 1 year. He shall comply with all the conditions and terms of the probation department as successfully complete his intervention plan and obey all of the conditions of the community control, and he shall pay the court costs. Now, in the event that the defendant fails to comply with these conditions or complete the intervention plan, the probation department will file a notice alleging that the courts are confident on you, Mr. Schoenberg, At that time, the court will conduct a hearing in which you'll be represented by counsel. If the outcome of that hearing is that you failed to comply, then at that time, the court can find you guilty, and then will be subject to sentencing you to a period of 6 to 18 months and fining you up to $5,000 plus a license suspension, 6 months to 5 years. All right, anything further, counsel?
No, Your Honor.
No, Your Honor.
All right, Mr. Schoenberg, you're off of pretrial supervision now, you're not under house arrest or anything like that. You do need to go down to the probation department right away and report to them that you've entered your plea today and are been granted intervention, and they will switch you over to that program, and you'll get copies of those conditions and so forth. Okay?
Do I get a fine?
No fine, no. No
Okay.
fine, just have to pay the court costs.
Okay, thank you.
All right. Go
Thank
down
you
to
very
probation.
much. Huh?
Go right down to probation.
Okay, go straight down there.
Thank you.
Thank you.
Please rise.
Got it?
Yeah.
Okay.
Thank you. Thank you.